I'm sentencing you to 12 years in the Tennessee Department of Corrections.
She stated that she did drink a bottle of vodka.
All right, we're here on one case out of Dixon County Circuit Court, 2025 CR 59, State of Tennessee versus Rebecca Ann Miles. Is the state ready?
State's ready, Your Honor.
Defense is ready?
This courtroom is constructed. I
have a camera set up on the witness stand so that you'll be able to see the witness on the camera. But if you need to move, Mr. Flanagan, feel free to do so.
All right.
This is a sentencing hearing, so the defendant having entered a plea to a number of counts previously, for the record, she entered a plea on May 26th of 2026 to count 2 DUI, first offense per se, Class A misdemeanor, count 4 reckless endangerment of deadly weapon, Class E felony, count 6 child endangerment of a child less than 8 years of age, Class B felony, and count 8 felon in possession of a firearm involving a prior felony, a Class B felony. Counts 1, 3, 5, 7, 9, and 10 were all dismissed as a part of the agreement. And the agreement was that she entered a plea open and concurrent to one another, and the court would decide the length of the sentence between 8 and 12 years exposure. The manner of service at the future sentencing hearing would be classified as a range 1 offender. Counts 6 and 8 are subject to 40, 35, 501. And then there's a separate case of 2025 CR 294 that was dismissed as a part of the settlement agreement. I've just read that from the waiver of rights that was entered, and I assume that is accurate, correct?
It is, Judge. And could I ask, she's got shackles on her feet. Does she have to be handcuffed like this in a sentencing?
I have no problem with removing her handcuffs in a sentencing hearing. So.
It's just easier to communicate with her. But she's got her ankles. Judge, and the main reason is we write notes back and forth, and it's easier.
I don't have a problem with that.
I have to pay attention to what I'm doing so you can write it. Thank you, Judge. Thank you, officer.
All right, you wish to make an opening statement, or you want to proceed with your proof?
I can make it very brief, Your Honor. Your Honor, the reason I'm giving an opening is because we did not go through a trial, so I'd like to provide at least a factual foundation, very brief, before we go through the proof. With that said, Mr. Flanagan, would you like to go ahead and call the rule?
I would. I'd like to call the rule before an opening.
Rule has been requested, so if anyone who is going to be a witness that is not a party to this proceeding must go outside of the courtroom and remain outside of the courtroom until you yourself are called to testify. You're not to discuss the testimony of any other witness with anyone until you yourself have concluded.
For the record, my first witness is going to be Officer James, and the state's as Officer Lewis. That's why they are remaining in the courtroom, Your Honor.
Judge, and the officer can stay if she wants to. I just want civilian.
Officer Smith?
You don't have an objection to the officer?
No, I don't have an objection.
Officer Howell, if you want to retrieve them.
Yes, sir. I just meant civilian.
I didn't want to answer why I want to go ahead.
That's fine.
Your Honor, this case involves January 22nd, 2025. It's about 3:45 p.m. Miss Libby Sanders is driving a short bus that is ultimately held by a private school, Nashville Christian School, I believe. The bus is going down Highway 70, coming from the direction, I believe, of White Bluff, and it's in the left turn lane to get on Highway 96. This is the intersection of Highway 70 and 96. While the bus is in the left turn lane, you're going to hear testimony today from a witness who said that further up Highway 70, prior to this crash, a car was going in a very erratic manner all over the road, scaring this witness to where she ultimately had to accelerate to a high speed to get around this car. This witness then went to the intersection and I believe was in the left lane while watching a school bus in the left turn lane, where this car came around and struck the school bus at a high rate of speed. You will hear from another witness who's the opposite lane, eastbound on Highway 70 with his crew, where he sees this car come around the curve at a rate of speed either at or above the speed limit, not braking, coming to a crowded intersection, ultimately striking this bus. The bus then catches fire. It's hit in the back left corner, where ultimately a fire erupts, and the bus driver, Miss Libby, has to take a 6-year-old KO and run up a hill with him so that he is not injured by this fire. You're going to hear that inside of this car, owned by the defendant, Miss Rebecca Miles, is a purse which has a prescription for oxycodone, as well as a purple handgun. Miss Miles, previously known as Miss Rebecca Fain out of Montgomery County, is a convicted felon for an aggravated assault, making a possession of a gun a Class B felony. Those are the facts there which will be shown today, as well as all the other materials for purposes of enhancement factors and the discussions that we will have at the end for your sentencing consideration, Your Honor. Thank you.
Mr. Flanagan, you wish
No,
state may call your first witness.
State calls Wendy James.
If you'll step up and place on.
I do.
Good afternoon, ma'am.
Good afternoon.
Please state your name.
Wendy James,
How do you spell it?
WendyJames,
Where are you employed?
with the Tennessee Department of Correction.
What is your role?
I am the pre-sentence investigation report writer for the 23rd Judicial District.
Officer James, were you assigned to conduct a pre-sentence report for Miss Rebecca Miles?
Yes, I was.
And do you see Miss Miles in the courtroom today? If you need to stand, that's fine.
Yes, I do.
Where is she seated? What is she wearing?
She is seated over by Mr. Flanagan in orange.
Your Honor, if the record could reflect, she's identified Miss Miles.
All right, the record will reflect that she has a defendant.
Did you interview Miss Miles?
I did.
Did you look at Miss Miles' criminal history?
Yes, I did.
Did you document all of that?
I did.
Did you do a strong R assessment for Miss Miles?
Yes.
And is that put together with an investigative report?
Yes, it is.
Did you also get victim impact statements from, I believe, a Miss Sanders
Yes.
and the parents of a child with the initials KO?
Yes.
Your Honor, if I could please pass forward an item.
You may pass it to the witness.
You've been handed a document, Officer James. If you could please look at that. If you please ensure that it is your copy. Is it a copy of your document that you had, the pre-sentence report?
Yes.
Okay. Your Honor, I would move to make that state's first exhibit.
All right, you want to make that copy to the exhibit? There is one in the court as well.
Yes, sir. I have my own copy as well, and I've shown it to Mr. Flanagan.
Right.
I believe in your report you put that Mr. Flanagan was appointed.
Yeah, if that's what it says,
Okay. Would it be possible that he was retained in this case?
it could be possible.
You have the officer's report in here of what happened on that date. Is that correct?
Yes.
I want to go through specifically starting with, I believe it says in the upper left-hand corner, page 7 of your report. Is that where the criminal history starts for Miss Rebecca Miles?
Yes.
Safe to say that Miss Miles has an extensive history.
Yes.
I believe she has a conviction for public intoxication. Is that correct?
Correct.
Resisting arrest.
Correct.
I believe when I counted them, 16 violations of bond condition. I believe you put them as contempt of legislative committee.
Yes.
9 prior assaults.
Yes.
That would include 7 or 8 of those domestic, correct?
7 domestic. Yes.
Did she have an aggravated assault felony conviction?
Yes.
Did she have a simple assault conviction?
Yes.
I believe you put in there she has 6 violations of probation.
Yes. Correct.
She has an escape charge,
Correct.
and that's a conviction. Actually, I say charge, but these are convictions.
Yes.
This does not include charges that may have been settled or dismissed in settlement, correct?
Correct.
She has 2 failure to appear convictions.
Correct.
So if you include the violation of probation, would it be safe to say about 36 admitted violations of the law?
I have 32 total charges and 6 VOPs.
So that'd be 38 possibly.
Yes.
Now, to be fair, one of those is a due care traffic
Yes.
infraction.
Traffic. Mhm.
So not including that, we have about 37 by your count.
Correct.
Does she have a theft? I believe I may have missed a theft conviction.
I believe she does.
Is it important for defendants to appear in court?
Yes.
And whether it's probation, community corrections, or parole, is it important for them to appear?
It is.
Is it important to abide by the terms of court orders and probation or parole orders?
Yes.
And she has an escape, not abiding by the order, correct?
Correct.
2, failure to appear is not coming to court when ordered to, correct?
Correct.
And when given orders by this court to not have contact or use drugs, have gun, whatever the condition was violated, she's been convicted 16 times of not abiding by those conditions, correct?
Correct.
Let's talk about treatment services. Based on your assessment, did you believe Ms. Miles could be helped by some treatment programs?
I do.
Did that include for her anger issues,
Definitely.
mental health issues,
Yes.
substance abuse?
Yes.
To your knowledge, those services are available at TDOC, correct?
Yes.
Let's talk about your strong R. Did you conduct the strong R assessment with her?
I did.
Now, you note the need for her to address things such as mental health and substance abuse, correct?
Correct.
But in your strong R, those actually came back as low needs. Is that right?
The reason they came back as low needs is because those are being addressed currently in jail.
So I want to get this clear for the record. So while she's in jail, these needs are now low because she is no longer having these needs while incarcerated.
Well, they're being treated.
So it's helping while
So-
she's in jail.
Yes.
Okay. So incarceration, she could be treated while incarcerated.
Yes.
In fact, treated to the point that these are now low on a strong R assessment.
Yes.
In Miss Mott's statement, did she ever mention anything about her gun?
No, she did not, and I did not ask.
She provided a statement about this incident. I believe in your report, she said that her husband had possibly cheated on her and she was going to a hotel room. Is that correct?
Correct.
But she never offered anything about this firearm.
No.
Okay. One moment, please. Thank you all. That's all that I have at this time.
Flanagan, you may.
Thank you. Ms. James, I don't know how many people you've interviewed, a lot, but this kind of jumps out that anger and substance abuse and low self-esteem are her main issues, are they not?
Correct.
No question about it.
No.
And as you indicated, she showed remorse. She was thankful that nothing worse happened to anybody.
She did.
And General Stevens asked you about programs to help her. Those can be addressed and are being addressed in the local jail.
Yes.
So she doesn't have to go to TDOC to get that help.
Correct.
Okay. Let me ask you this, and you're more experienced than I am, and I'm just going to cut to the chase. Do you think she is the candidate to go immediately onto probation?
I do not.
Okay. So you think she's receiving help in jail? Do you think a split confinement would be something to consider for her, to stay in jail, to keep getting help?
I do think she needs some rehabilitation before
Yeah.
she goes back into society. Yes.
Okay. All right. Thank you. That's all.
Officer James, you said that she showed remorse. I want to go through her statement. She said, "What if I had hurt someone?" Correct?
Yes.
So that implies she didn't hurt someone, correct?
It could.
Okay. Now, you're talking about rehabilitation. You think she needs something to rehabilitate her before she's ever trusted out among everyone else?
I do.
The free world, as they say.
Yes.
Do you think she could be a danger with her anger and substance abuse to everyone else?
I do.
And that can be on the road with a DUI, correct?
Correct.
That could be at home with any of her family members when you have, I believe, almost double-digit convictions for domestic assaults.
Correct.
Nothing further. Thank you.
You make assessments based on your conversations with people about whether or not she showed remorse, and your opinion is she showed remorse, right?
She did.
Okay.
Nothing further, Your Honor.
All right. Thank you, Ms. James. Step down. Call your next witness.
State calls Akasha Green, Your Honor.
Come right around and follow what bailiff is showing you. We're going to bring you up to the witness stand. Right up here and right hand.
The whole truth and nothing but the truth, so.
Yes.
We'll let you pledge allegiance to the flag if we have one. Thank you. Have a seat, please.
Good afternoon, ma'am.
Good afternoon.
If you could please speak into the microphone so we can record what you're saying.
Yes.
Can you please state and spell your name?
Akasha Green, AKASHA-GREENE.
Miss Green, do you recall an incident on January 22nd, 2025 that brings us to court today?
Yes.
Where were you at when this occurred?
I was driving from White Bluff to Dixon on Highway 70.
Westbound, you think?
Yes.
And what happened while you were, was that in Dixon County? Let me ask that. Was that in Dixon County?
Yes, sir.
What happened while you were driving?
I was behind a vehicle that was driving erratically.
What do you mean by driving erratically?
Swerving in and out of the lane, hitting the brakes, speeding up, just not abiding by the traffic laws.
Did you feel safe?
No,
So what did you do?
I passed them.
Okay. How did you pass them?
I got above 80 speeds and passed them around Catfish Kitchen.
So you had to go over 80 miles an hour to safely get around them?
Yes.
Were you in fear for your own safety being behind this car?
Yes.
And it took 80 miles an hour for you to be able to safely get around them?
Yes.
Was that the last you ever saw of that car?
No.
Okay. What happened?
After we got to the red light, the intersection of 96 and 70, within just seconds of being at the light, there was an impact.
Okay. Where were you? Let me see. 1 second. Look towards her. There we go. We're figuring out some technical things. 1 second, please. Does this look familiar to you?
Yes.
Okay. And what does this appear to be?
an intersection. It looks like 70 and 96.
And on the right side, I believe, is that a sign saying turn left to go to 96?
Yes.
Is this the intersection that you were at that day?
Yes.
Where would you have been, in the slow lane, the fast lane, or the turn lane?
The fast lane.
And how far back were you?
3 cars.
Did you ever see a school bus that day?
Yes.
Where was it?
It was in the turn lane, the left turn lane.
And what happened?
The light, the green light for the bus to go came on, and the car that I passed slammed into the back of the bus.
Where would the car that you passed had to be to slam into the bus?
It was in oncoming traffic going around everyone in the intersection.
And during that time, it struck the school bus?
Yes.
Would it make sense to say the back left side, perhaps?
Yes.
Did you cooperate with police and give them a statement?
Yes.
Now, just for the record, did you ever see who the driver was of that car?
No.
But you gave police a statement as to what happened that day.
Yes.
That's all that I have at this time. Thank you.
Mr. Flanagan, you have any questions?
I do not, Judge. Thank you.
Thank you, ma'am. You may step down. You may have a seat in the courtroom, or you may be excused.
Criminal witness list.
Mr. Stevens, your
Yes, sir. State calls Jackson Miller. I believe so, because she seemed to look at it, and I would say yes. I noticed she looked down at it. I think she can see it.
Affirm testimony, give the truth, the whole truth, and nothing but the truth.
Good afternoon, sir.
Yeah.
If you can, make sure to speak into the microphone when answering questions. Please try to avoid nodding your head or shaking it. Answer either yes, no, or whatever your answer is. Say it aloud. Sir, please state your name.
Jackson Miller,
How do you spell that?
Jackson Miller.
Mr. Miller, what do you do for a living?
I work at Greater Dixon Gas Store.
Okay. What were you doing? What was your employment January 22nd, 2025?
I was still working there.
Do you remember an incident occurring that day that brings us to court today?
Yes, sir.
Where were you at?
I was sitting at the intersection where it happened.
Okay. What happened? Where was let me back up. I'm sorry. Where was the intersection?
96 and 70.
Which way were you facing?
I was at the red light on 70 facing towards White Bluff.
So you'd be going eastbound.
Yes, sir.
While you were there, what did you see?
So I was sitting at the red light. I was in the passenger seat. I was looking at my phone, and I looked up, and the bus was sitting in the turning lane to turn on 96. And about the time when I looked up, I seen the car coming towards us, and the passenger side had caught the driver's side of the bus, and that's when the wreck occurred.
Did you say anything to your friends right before it occurred?
Yeah, I was like that. The car's about to hit the bus.
Did you see any braking?
No, sir, not that I seen.
Okay. What happened to the bus?
She hit it pretty hard, and then it went up in flames.
In flames. I'm going to show you something. It may be if you can let us know if it's on the monitor in front of you, or if not, that's whenever it comes up. Can you see it on the monitor?
Yes, sir, I can.
What do we appear to be looking at right here?
So that is the truck that I was sitting in, and that is after the wreck occurred.
Is it okay if I zoom in?
Yes, sir.
Maybe a little blurry, but I'm zooming in. What do we appear to see here?
There's firefighters putting out the bus that's in flames.
That car that's beside it, the red car, does that appear to be the car you saw?
Yes, sir.
Okay. Does that appear to be an accurate depiction of what you saw that day?
Yes, sir.
Hand you an item? Does that appear to be a printed copy of the image that you're looking at?
Yes, sir.
Your Honor, state moves to make that states the next numbered exhibit.
I believe this pre-report was made an exhibit, so this would be number 2.
Yes, sir.
Go ahead.
Do you believe that red car was driving in a proper manner, obeying the rules of the road?
Not at that location, sir.
What do you think would have happened if she had not struck the bus?
I believe she would have hit us head on.
That's all that I have. Thank you.
No questions.
Thank you, sir. You may have a seat in the courtroom, or you may leave it.
State calls Officer Daniel Lewis.
And be placed under a solemnly swear from the testimony about to give in this case to be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
Good afternoon, sir.
Good afternoon.
Please state your name.
Daniel Lewis, sir.
Please spell it.
DanielLewis.
Where are you employed?
I'm employed at the Dixon Police Department, sir.
How long have you been in law enforcement total?
In total, 9 years, sir.
Were you in that capacity on January the 22nd, 2025?
Yes, sir.
Who are you with?
I was with the Dixon Police Department Patrol Division.
Do you recognize the defendant in this case? And if you need to move, that's fine.
Yes, sir.
Who is that?
That's Miss Rebecca Miles, sir.
Does she also go by Rebecca Fain based on your investigation?
Yes, sir.
Was there an incident with Miss Miles on that January 22nd, 2025 date that brings us to court?
Yes, sir.
Where did that occur at?
That occurred at the intersection of 70 and 96.
Now, we're in a sentencing hearing, so this is not for the full proof of guilt that's already been established. But very briefly speaking, can you provide a basis of what your witness interviews and investigation provided?
Yes, sir. Miss Miles was traveling westbound on Highway 70 East, striking a bus at the intersection, causing the bus to engulf in flames.
Was that her car?
Yes, sir.
Did she admit to driving?
Yes, sir.
Who was on the bus at the time of the incident?
There was a bus driver and a 6-year-old child.
Okay. Where did they have to go?
They were on the hill going towards the church.
Okay. Was there anything inside of Miss Miles have a purse or any other item in her car?
Yes, sir. She had a purse in the car.
What was inside the purse?
There was a prescription bottle for oxycodone and a purple Ruger pistol.
Who was the oxycodone prescribed to?
To her, sir.
Did you notice anything odd about its counting of the pills?
So it showed that it was filled the same day, and it was supposed to have 120, and when counted, it was 82.5.
So more than a quarter gone?
Yes, sir.
Okay. Did you ultimately get a sample for blood for chemical testing?
Yes, sir.
I'm going to hand you an item, please. If you can please look at that.
Yes,
To your knowledge, was this tested for blood alcohol content?
Yes, sir.
Please look at that item. Who is it addressed to in the upper left-hand corner?
To me, sir.
And who is the subject of this matter?
Rebecca Ann Miles, sir.
What does it show? Is this a TBI analysis of the blood?
Yes, sir.
What does it appear to show her BAC to be?
It shows 0.113,
What's the legal limit in the state of Tennessee, to your knowledge?
0.08, sir.
Would this have been collected after the wreck?
Yes, sir.
Okay. Your Honor, state moves to introduce that as the next numbered exhibit. I believe it'd be 3.
3.
If I can hand you another item, please. Who's that addressed to?
To me, sir.
Who's the subject in this matter?
Miss Rebecca Ann Miles.
Does this appear to show a toxicology examination by the TBI?
Yes, sir.
What does it show to be positive or present in her system?
Oxymorphone.
Okay. And what does it show the quantitative amount to be?
9 mg/ml.
Nanograms per milliliter?
Yes, sir.
State introduces that as state's next numbered exhibit. I believe it'd be 4, Your Honor.
You can just hand them to me. Save him having to work so hard.
Yes, sir.
You said you've been in law enforcement how long?
9 years now, sir.
How old are you?
I am 32.
You've actually been in law enforcement for 32 years, haven't you then? And I have known his father, who was former chief of police and has been in law enforcement since before you were born.
Yes, sir. Since 87, I believe it was.
I think so.
That's about as long as I've been alive, so there you go. Did you ever speak with Miss Miles?
Yes, sir. After the crash, we went up to the hospital, and I did get to speak with her.
Okay. Was she coherent?
Yes, sir.
Able to answer questions as to day, time, and things of that nature?
Yes, sir.
She admits to drinking?
Yes, sir. Earlier that morning, she stated that she did drink a bottle of vodka.
A bottle of vodka?
Yes, sir.
So not some shots, but a bottle?
Yes, sir.
She admits to taking her pain medication?
Yes, sir. That morning as well.
Where did she tell you she was going that day?
She stated she was going to town.
For what?
I believe she was going to go to the store, is what she said.
Did she ever say she was in an incident with her husband and needed to go to a hotel?
No, sir.
So if she told that's probation, would that be inconsistent with what she told you?
Yes, sir.
Now, the gun that you recovered, what color did you say it was?
It was purple, sir.
And that was in her purse,
Yes, sir.
along with her medication.
Yes, sir.
All these events, they occur in Dixon County.
Yes, sir.
And the defendant in this case and the person involved in this investigation, the one driving the car, that was Miss Rebecca Miles.
Yes, sir.
That's all that I have at this time. Thank you.
Mr. Flanagan?
Yes, sir. So what was the blood alcohol point?
0.113.
Okay. So that's really not consistent with drinking a whole bottle of vodka that morning, is it?
No, sir. It's not.
Okay. And the pill count, just because they weren't all in the bottle doesn't mean that they weren't somewhere else.
Correct.
Okay. And she didn't take 30 or 40 pills or she would have been dead. You would agree with that? Okay. And she was coherent when you talked to her at the hospital. So
Yes,
she
sir.
wasn't all that impaired, was she?
I couldn't speak on impairment other than what she
Okay.
could tell me.
Okay. So there's no evidence of impairment and she seemed coherent.
Yes, sir. She was
Okay. Okay. You're a much better witness than your dad. Okay. Who I've known longer than you.
All right. Let's clean up a little bit of that. When did she say she had the bottle of vodka?
I believe it was 7:15 that morning.
What time did this incident take place?
3:45. At that point, we were around the hospital around 6 o'clock or so.
So the BAC could make sense. Now, Mr. Flanagan kind of mixed it in and said, so she's not impaired and blah, blah, blah. Did you believe she was impaired?
It's assessment of what I'm saying.
Seems to be a little inaccurate assessment.
Yes, sir. Did he tell you, did he sneak in that he said that she was under the, so she wasn't impaired? Did you say yes to that?
He said I snuck in something.
Yes, sir.
Judge.
I'll
I'm
read.
concerned about this.
I'm sorry.
Sustain the objection.
When you spoke to Mr. Flanagan just now, did he ask you whether or not you thought she was impaired?
Yes, sir.
What did you think at the time of?
I still think she was impaired at the time of the incident.
Now, he's mentioned that she's not impaired and was coherent. Do you remember something along the lines of that?
Yes, sir.
Did you believe that she was under the influence at that time and too impaired to drive?
Yes, sir.
Now, drinking a bottle of vodka, you testified to what time in the morning?
7:15 is what she stated.
And this came out at about 3:45 p.m.
Yes, sir.
So some time has lapsed. Is that a fair assessment?
Yes, sir.
Nothing further. Thank you.
Nothing further.
Thank you all. Lewis, you may have seats.
Thank you, sir.
State calls Officer Bridget Smith. Good afternoon, ma'am.
Good afternoon.
State your name.
Bridget Smith,
How do you spell that?
BRIGET
Where are you employed?
City of Dixon Police Department,
How long have you been employed in law enforcement?
4 years.
Just for the record, how many times have you testified at a hearing?
This is my first time.
Okay. Were you in that capacity January 22nd, 2025?
Yes, sir.
Do you recall receiving a call that day regarding a school bus?
Yes, sir.
And can you walk us through that? What happened?
It was dispatched as a crash at 70 and 96. As I was en route, as I'm topping the hill on 70 East, I observed the flames, or not the flame, more like the smoke, the black smoke, stuff like that. I arrived on scene where I then observed a bus fully engulfed in flames that resulted in the crash.
Body camera at that time?
I do.
If I could please show her footage. I'll try it again. Have you seen your body camera? Does this appear to be your footage?
Yes, sir.
I'm going to start at 2 minutes, 50 seconds into the video. The timestamp at the top right is 15:49. You appear to be walking quite a bit, so I've frozen it at 15:49, 45 seconds in the upper right-hand corner for the record. What do we appear to see here?
A bus fully engulfed in flames, sir.
Okay. And did you assess ultimately if anyone was inside that bus?
I was not close enough.
Did you speak with other officers?
Later in the video, yes, I did.
Okay. I'll continue to play. Here, 15:50:18. Was the bus ultimately ever put out by firefighters?
Yes, sir.
Did you ever see the condition it was in when it was
Yes,
finally extinguished?
yes, sir.
We pass an item.
Thank you.
I've handed you a picture. Does this appear an accurate depiction of what you saw that day, the condition of the bus when it was extinguished?
Yes, sir.
Your Honor, state moves to introduce that as state's next numbered exhibit. I'm going to continue to play. Did you just say it was freezing?
Yes, sir.
Now, currently, is it July 28th today?
Yes, sir.
Is it fair to say it's very hot outside today?
Very.
Not in this courtroom.
I'm freezing currently.
Outside of this courtroom, would you say it's fair to say it's pretty hot?
Yes, sir.
Okay. Now, with that said, January 22nd, was it cold that day?
Very cold.
Okay, I'm going to continue to play. So pausing it here for the record, 15:51:02. What were you just notified by another officer?
That the other party later determined to be the victim was on top of the hill. It's the entrance and exit of the church.
Okay, did you walk all the way up the hill?
I absolutely did. Yes, sir.
Okay.
I just grabbed him and got him. Hi, you okay? For other stuff. His mom has been at 4 o'clock. I'm trying to get a hold of my boss.
I'm pausing this at 15:52:39. Was the child in this case, was he very talkative to you?
No, sir.
Continue to play.
Oh, I don't have a phone. Okay? Yeah? You are? Do you have your dog anything? Okay, I'll call you in just a minute, okay? See you back in here, okay? Okay? It's gonna be okay. Are you okay? Just shake it up. I would feel better.
Approach.
You may.
For the record, I paused it at 15:53:37. We're going to resume.
EMS power. And little one. Yes. And I need to have the driver and the car. Where were you guys? We was just like right behind them. I just seen part of it. Whenever the car just. Okay. So I'm checking you in the video, okay? What happened? So I was sitting at the light, wait for the arrow to turn, like I do all the time. He was sitting behind me, and I talked to him on the way because he's the only kid on the bus. So I was asking about his clothes, and he was talking about his cars that he had at home. And whenever he was talking about that, I was looking around, and I looked in my mirror, and there was fire, so I just grabbed him and jumped down. Yes. Yes. I just saw fire.
So you were waiting at the red light?
Yes.
When you were in, talking about
So boy, next thing you know, you were hit.
And I was in the middle of the intersection. I looked back and I saw fire, and I just grabbed him and ran. My phone's still in. Well, it's
114 Tennessee.
that's why. No, that's
You got somebody. You need a phone.
Unplug 15:55:30. What would you describe the condition of this bus driver as?
Sheer panic mode, like her adrenaline hasn't dumped yet from what she had been through.
Who does she appear to be concerned about?
About the child and not herself.
I'll continue to play.
And my lady with all the kids I have in the car was in there, like on my bus that I had just checked on
04168876.
I just checked them all up. I'm sorry.
What's her name?
Who?
Mother.
Oh, sorry. Alpha, an OA and a blue.
I'll get Jerry to go over that. Jerry, he works in Fairview. That would be easy. I'm very grateful that you're in that movie. That's very traumatic, very scary. You were just very brave little boy. And you saved that mother's child.
It's like a little blue car. It kind of looks like a blue car, like a Tesla maybe. Yes. When you pull into the right underneath the Flying J side, she's the only one that'll be open.
Thank you.
Thank you.
I just did an amazing job. You didn't even have time to think, you just did it.
Yeah.
And that's what's wonderful, because a lot of people are pros. Absolutely.
All right, I'm stopping this at 15:57:45. Is all of this an accurate copy of your body camera that day?
Yes, sir.
The mental condition, mental state of the bus driver.
Yes. Yes, sir.
Did this appear to have affected her?
Absolutely. It would have affected anybody.
Okay. Thank you, officer. That's all that I have.
Questions, Mr. Flanagan?
Did you say this is the first time she's ever tested? Right. I don't want to be the first cross-examiner.
All right. Thank you, ma'am. You may step down and have a seat in the courtroom if you'd like.
Libby Sanders. Good afternoon, ma'am. If you can, please speak into the microphone so we can record what you're saying. Try to avoid shaking your head and nodding. Just answer with verbal answers, okay?
Okay.
Please state and spell your name.
Elizabeth Sanders, ELIZABETTASANDERS.
Do you go by Libby?
I do.
Libby?
Yes.
Ms. Sanders, how do you feel today, right now?
Kind of all over the place, to be honest.
You feel a little nervous?
Yes.
Okay. Well, I'm going to ask you some questions. Are you a bus driver?
Yes.
Who are you a bus driver for?
Nashville Christian School.
Were you a bus driver for them in January 22nd of 2025?
Yes.
Do you recall an incident happening that day that brings us to court?
Yes.
If you could, I'd like to ask you about right before the incident, did a wreck happen? Let me ask you that.
Yes.
Right before the wreck, what were you doing?
I was sitting at an intersection waiting for the green arrow, and I was talking to one of my school kids.
Okay. Mr. Flanagan to be in his way. I'm going to show you a picture if I can. Leaving it here, not in your way. Does this look familiar, ma'am?
Yes.
Okay. Is that the intersection that you were at that day?
Yes, sir.
Is that the intersection of Highway 70 and 96?
Yes, sir.
What county is that in?
Dixon County.
So where would you be in this picture?
The left lane, the left turning lane.
To turn left onto Highway 96?
Yes, sir.
Who was in the bus with you that day?
Christopher Owens.
Okay. How old is he?
He was in first grade.
Possibly about 6,
Yes.
but less than 9 years old. Is that fair to say?
Yes.
What was he talking to you about?
We were talking. I was trying to keep him awake so he wasn't asleep when he got to his next bus stop, as he usually does. And I was talking to him about his favorite cars, and I asked him, "What is your favorite car?" And he told me it was a yellow Bugatti. And I still think that's a little funny for a first grader, but that's what we were talking about.
Seems to have a little knowledge about vehicles.
He does.
Was Christopher talkative?
Yes.
Right. What happened while you were there? What happened?
So when he said that, I kind of laughed, and we were still waiting on the green arrow. So I kind of looked back at him and smiled at him. And then I felt like I got pushed, and I looked up, and we were in the intersection, and I looked in the mirror on my left side, and I saw flames up the side of the bus.
Do you think the bus was on fire at that point?
Absolutely.
So what did you do?
I turned to look at Chris, and I told him to come here, and I grabbed him, and I saw my purse right next to him. So I just grabbed them both and ran up the hill at the First Baptist.
Did you have a cell phone?
Yes.
What happened to it?
It burned in the bus.
Cell phones are almost part of our body now that we take everywhere with us. But did you even have time to grab a cell phone in this case?
No, and I always sit on it like it's under my hip for emergencies.
and I wasn't thinking about it at all.
Okay. What would have happened if you had been on the bus longer?
Oh, I feel like we would have died. It went up really quick.
Okay. Was it a total loss to the bus completely engulfed in flames?
Yes, there was nothing left.
Okay. Did you talk to officers on scene?
Yes.
I want to talk about, did you fill out a victim statement in this case?
Yes.
Going through that, did you go back to work the next day?
No.
How long did you take off work?
Until I think Monday or Tuesday of the following week.
Was that as a result of this crash?
Yes.
Did you still feel safe driving at that point?
I was much more aware, but I was told Chris didn't want to ride the bus unless I was there, and so I wanted to be there for him.
So did you drive the bus for Chris?
I did.
Talk about your route. When you take a route to get to places, did that change after this day?
Yes.
What changed?
I used to go out the side entrance by Greystone, and I would turn in that turning lane to wait for the green arrow to turn, because I thought that was the safest route to go. But I can't do that anymore. I now go all the way in front of the church and all the way around, and I'll sit at that the other side of the light. And before I go, I look at least 4, sometimes 6 times before crossing.
Does that have a long-lasting impact on you?
Yes.
Are you anxious when you approach that intersection now?
Yes, but I don't let the kids see that.
Okay, so you're hiding it for the kids?
Yes, because they still talk about it.
I'll talk about the crash.
They do.
I'll talk about Chris. Has he changed since this incident?
Yes.
How has he changed?
He doesn't fall asleep hardly at all anymore. It's rare. And I had changed my bus seating. He used to sit, well, he does sit behind me now, but there was baseball bags and softball bags coming through, and I saw that they were hitting the little ones. And so I was like, I'm going to clear a space out on the seat behind me so y'all can sit y'all stuff there. It's not hitting anybody. Chris didn't like that because that was his seat. And he came to me and he was like, can I please have my seat? He said, I need to sit there. And I moved it, and I made sure that he's able to sit behind me. He doesn't want to sit anywhere else but behind me.
Okay. Did you ever offer him to move a row or 2 back to be with a friend?
Yes, and he refuses.
He refuses. I believe you put that in your statement.
Yes.
Okay. What long-term effects has this had on you?
I do have anxiety medication, but it's not as bad. A week or 2 after it happened, my eyes were twitching for a while from the stress. And I just, I noticed I always check my mirrors. I'm really good about that. But I feel like I check my rear view mirrors a whole lot more.
Now, the judge today has some decisions to make that include the length of service of whatever the sentence is between 8 to 12 years, and ultimately whether this involves a full probation or part probation. Do you think probation should be given in this case?
No.
What would you like to see happen in this case?
The max sentence. I don't want this to ever happen again or to anybody, because it could have been so much worse. And the what ifs play in my head all the time.
Okay. Do you think she'd be a danger driving around with others?
Absolutely.
Okay. Is there anything else you'd like the judge to know in this case?
So my students, to this day, they still talk about the bus fire and the bus crash, because some of them were around when it happened, because I had just let off my bus kids at the First Baptist. And so their parents were driving around them. And I have to tell them to change the subject because it makes Chris very uncomfortable, and you can tell he gets very silent and very reclusive. And so I think it's had an effect on a lot of my smaller bus children, and I just feel like she's a danger.
Thank you. That's all that I have.
No questions.
Thank you, ma'am. You may sit down.
Stay calls, Ms. Owens.
Here, place our clerk to my right. Please back that up. A little bit of an awkward situation.
Do you solemnly swear for giving me the truth, nothing but
Yes.
Good afternoon, ma'am.
Hello.
If you could please speak into the microphone, speak clearly. Try to avoid shaking or nodding your head. Answer aloud. Please state and spell your name.
Alva, A-L-V as in Victor A, last name Owens, O-W-E-N-S.
Miss Owens, do you know a Christopher Owens?
Yes,
Who is he?
he is my son.
Do you recall an incident about January 22nd, 2025 that brings us to court today?
Yes,
How old was he that day?
he was 6. Yes, he was 6, turned 7.
Okay. Let me just ask you, how are you feeling right now?
A little shaken up.
Okay. I want to go back to that day and ask you a few questions about that day and then what's happened since. Where were you that day when you first heard about an incident?
I was sitting at the Flying J, which is where his bus stop was in Fairview, waiting on Miss Libby to drop him off.
Did she drop him off?
She did not. I started getting concerned because Miss Libby is very prompt, and she may be at the most 1 minute late. But I try not to panic. After about 10 to 15 minutes, I started to panic a little. I'm like, okay, maybe there was a parent that was running late at the previous stop. So I didn't worry. 20 minutes in, Miss Libby normally sends a text if she's ever going to be late. I didn't get a text message. So I called my husband and said the bus wasn't there yet. Again, I tried to wait out a little bit longer. Soon after, I got a call from Miss Brazel. At the same time, a Fairview police officer was pulling up next to my car asking me, was I Alva Owens?
Who is Miss Brazel?
She is the head of the lower school at Nashville Christian.
So you're sitting here waiting for your child and an officer comes up to you?
Yes.
And what happens?
I rolled out my window and he asked me to verify who I was. He informed me there had been an accident and that I needed to go to, it was a church in Dixon. At the same time, I'm answering the call and Ms. Brazel is confirming the same information.
Okay. And describe what kind of a child was Chris before this date?
He was a very daring child, a typical boy, jumping off of everything.
Jumping off of everything?
Yes.
Did he take risks?
Oh, yes. Christopher actually fractured his face in kindergarten because he was using the tables as parallel bars.
Okay. All American boy, is that safe to say? Okay. And this day, was Christopher involved in an accident to your knowledge? He was.
He was riding the bus Miss Lee was driving.
Now, just for the record, you weren't there at the scene, correct?
I was not.
Did you notice anything about, if Christopher was quiet, would that be odd?
Very odd.
How's he been since this day?
He is very reserved now. He's clingy. He doesn't want to leave our side a lot. He's more reserved. He's afraid of fire. When we had to freeze the snow and ice this winter, our power went out and we lit our fireplace for the first time. He did not want to be around the fireplace. We had to calm him down and then explain that there was only source of heat we had at the time. But
did he ever tell you about his concern about what he watched for the fire?
Yes.
What happened?
He had a flashback above the fire on the bus. It took Christopher a while to talk to us, though. He did not want to relive that. Actually, before I heard the whole story, he was talking to a friend that doesn't go to his school that we had invited over to the house for a play date. And I overheard him telling the little friend I was in an accident and that his bus caught on fire. And Miss Libby lost all her stuff, and he lost his backpack. And that he was scared, but actually he never would completely open up to us. It was another 6-year-old that he opened up to.
Is it safe to say that this has changed him?
It has. It has.
Did you give a victim impact statement to the probation officer?
I did.
Okay. Everything in that correct to the best of your knowledge?
Yes.
Now, the court in this case has some decisions that will be made. Are you aware that Ms. Miles faces anywhere from 8 to 12 years?
Yes.
And that could be probation, partial probation, or to serve in the Tennessee Department of Corrections.
Yes.
What are you wanting to see happen in this case?
To serve her full time in the Tennessee Department of Corrections.
Would that be 12 years when you say full time?
The full 12 years. I don't want another parent or anyone to have to go through this. This has impacted not just my family, Miss Libby's family, the whole Nashville Christian family, because there were other kids that witnessed that accident.
Is there anything else you'd like to tell the judge?
I'm here today because I love my child. I want to protect him, and I don't want any other parent to have to sit here in front of you to experience this again.
Thank you.
No questions. Thank you.
So you can have a seat in the courtroom if you like.
State's final witness be Mr. Owens.
Right around here, raise your right hand towards me.
Yes.
Good afternoon, sir.
Afternoon.
If you can, please speak clearly into the microphone. Try to avoid shaking or nodding your head and answer aloud. Please state and spell your name.
Christopher Owens, Kris. Topher. Last name Owens, OW.
Is there another Christopher Owens in your family?
Yes,
Who is that?
my son.
How old is he?
He's now 8,
How old was he on January 22nd, 2025?
6.
Do you recall an incident occurring that day that brings us to court?
Yes, sir.
Now, I want to talk about Chris before this incident. Can you describe your son for me?
Oh, absolutely. Prior to the incident, he was a bright, outgoing, lovable young man that he was a child that everybody loved. You could say that he was almost mayoral in character. Loved to be around people, kind of shaking hands and kissing babies. Personality, kind of life of the party. Didn't meet a stranger. Just was kind-hearted individual.
Would it be odd for him to have been quiet at that time?
Yes.
Do you recall an incident happening involving a crash January 22nd, 2025 with your son?
Unfortunately, I can't forget it. It was a day that changed my son, who went from being the life of the party, outgoing, to now being reserved and withdrawn in a state of our fear almost. There still remains seeing the thing that you're supposed to be safe in, which is the bus, experiencing an accident where the bus catches on fire. And at that age, their belongings are not just stuff like we characterize things as adults. Their belongings mean something to them.
Did something happen to his belongings that day?
Unfortunately, yes. His belongings perished with the bus. And he saw the bus go up and he was worried about his brand new backpack that he just got, his new water bottle. Those were things in the work that was inside because of school. Those are things that he worried about and still does.
Is he, as you talked to him, as mayoral, shaking hands, kissing babies? Is he that way now?
Not as much, no.
What differences do you see?
He is much more reserved, much quieter, almost saddened in his personality now. There was lots of fear when it came to riding the bus again.
Does he still like riding the bus?
He finds comfort in the bus driver because, she saved him. And so he finds comfort there. But it took a lot of parenting and counseling and coaching to get him to the point where he was willing to get back on the bus or be by a bus.
Do you think this has had an emotional toll on him, to say the least?
Absolutely.
The judge in this case today has decisions to make, and he can decide anywhere between an 8 to 12 year sentence length, and he can decide the manner, whether it be full probation, part probation, or to serve the sentence. What do you want to see happen today?
12 years in prison. Decisions were made that day that not only impacted my child, and we don't know what that long-term impact is going to be, but it also impacted so many other people that have to live with the memory and the thought of a bus being on fire that had people on there. It's every parent's worst nightmare, every first responder's worst nightmare, to come to a crime scene that has children involved, and especially children on a bus. Children are our future. They hold a spot in our heart. They're what we look at as hope. And when you have to walk up on that and do your job, or if you have to experience that, that leaves an indelible mark that will always be there. Some people are able to move past it. Some people aren't. It is definitely for something that thankfully or could have been prevented. We're thankful that it was handled in the way that it was handled, and everybody did an amazing job responding to the incident. However, because the decisions were made that day to get in the vehicle and drive it inebriated under the influence, that could have changed what our statement is today, because our son, to whom we love dearly more than anything else, could not be here today.
Is there anything else you'd like the judge to know?
It's been difficult on all of us, as you can imagine. Decision making is a skill. I pray and I hope that she no longer has the ability to impact families or first responders or small children again in the near future, and that she has the opportunity to understand how much of an impact that this has caused on our family. You go from a little boy that sees the world as amazing and large and is curious to a scared young man, a scared little boy who no longer has that wonder in his eye, because he knows now that not only do bad things happen, but bad things could happen to him. And as a father, my job is to protect my child, and not being able to do that hurts. And I don't want any other fathers or mothers to be in a position where they can't protect their children because of bad decisions.
Thank you. That's all I have.
No questions.
Thank you, Mr. Owens.
That's the state's proof, Your Honor.
State has rest. Mr. If you wish to offer proof,
No proof other than a statement in allocution.
all right. Your client wishes to come
You
to
are
the
entitled
podium.
to make a statement.
If she's going to take the witness stand. then
No,
I guess-
she can do it at the podium since it's an allocution. She won't be under oath and won't be prosecuted. So you're free to make a statement, ma'am.
I'd like to begin with expressing my deepest, sincerest apologies to the families that were impacted and victimized that day on the bus. I truly am sorry. I thank God every day that goes by that I'm not grateful that I'm the only one that got physically hurt that day, because I wouldn't have been able to handle it if I hurt someone else because of my negligence that day, let alone a child. I've tried to make the best of my time here. It's been a long 10.5 months, but I've tried to make the best of my time here. I've taken anger management classes and graduated 2 of them. I've taken and graduated 2 domestic assault classes. I've gotten baptized, and I attend an AA program every week since October. And if just given the chance, I'd like to get out and continue my program. That's first and foremost, will be my sobriety. It's important, working a program and doing my meetings and getting a sponsor and being accountable for my actions. I don't know what else to say or how I can express how sorry I am to you all, that y'all had to go through that your children had to go through that. I made bad decisions that day, sir. Yes, you were right. And they're decisions I got to live with for the rest of my life. And I'm sorry. That's it, Your Honor.
Okay, you may have a seat. Otherwise, no proof.
All right, Mr. Stevens, you can be your case.
Go to 4035-102, the purpose of incarceration. We go through some factors. Punishment shall be imposed to prevent crime and promote respect for the law by providing an effective general deterrent to those likely to violate the criminal laws of this state. Part B, restraining defendants with a lengthy history of criminal conduct. I'd like to start going through this TCA. The legislative intent is clear. We have Ms. Miles, who has, when you add these 4 new convictions, 40 convictions in her life. You heard from probation today about all those convictions. I believe it was more than double digit on not abiding by court orders with conditions of release with domestic assault. I believe it was 9 total assaultive offenses, 7 of those, 6 or 7 being domestic in nature. And she's a convicted violent offender with aggravated assault. She's been given chances before to abide by the terms of probation. You saw how many convictions she's had for that, how many, more than a handful. Ms. Miles has a history showing that she's a danger to others. When you go to the enhancement factors, 4035-114, you can look at number 1, and I don't think we could be any clearer on this. The defendant has a previous history of criminal convictions or criminal behavior in addition to those necessary to establish the appropriate range. She has a substantial criminal history. Factor 3, the offense involved more than 1 victim. We have Ms. Sanders, Ms. Libby Sanders, and we have the child, Chris. Number 4, a victim of the offense was particularly vulnerable because of the age or physical or mental disability. We have a 6-year-old. Factor 9, the defendant possessed or employed a firearm, so in this case possessed, during the commission of the offense. When this bus was hit, she had a gun in her purse. So I think that would go towards the reckless endangerment at least, and towards the child endangerment. Now, Your Honor, let's say there was no crash that day. Let's say this was simply speeding, being pulled over for going 10, 15 miles per hour over. And then they go through your purse, let them have a search, and they find in your purse a gun and you're a convicted felon with a B felony or the prior violent felony. That in and of itself is age 12 years. And it's at 85% under 4035-501. I believe it's subsection Y for the gun. That in and of itself, having that gun in her purse, along with her prescription medication, is age 12 years at 85% by itself. But we don't have just that. We have a person who has consumed alcohol, a substantial amount earlier in the day, where ultimately she's still a .113 at the time of this accident. She goes around is driving recklessly, putting other citizens at fear. Citizens who you heard from one today, Ms. Green, saying she had to go over 80 miles an hour to safely get around her so that she was not hit because she didn't want to be nearby her. She was driving erratically, braking, scaring him. So Ms. Green goes ahead and goes up to this intersection, and across the street's Mr. Miller sitting with his coworkers going through his phone where he says this car's about to hit this bus. And he said that if she had not hit them, she was projected to go straight on, head on into him. She hits the school bus, ignites it on the driver's side. It catches fire. I think it's safe to say this traumatized driver has to grab this child, leave her phone, leave her possessions, whatever she cannot get, and run for the hill, literally and figuratively. Having to run up this hill towards this church, taking a little 6-year-old who has gone from being fearless, using tables as little bars to jump around with, not fearful of anything, and the talk of the town, wanting to talk to everyone, and scaring him. You saw the video. He gets out of that car and he doesn't even want to look at Officer Smith. He won't say anything. He'll just nod and maybe say a couple of words the entire video. It's had a long-lasting impact on him. The ice storm came through this year. You heard testimony that he now looks at that and he's afraid of fire. He's afraid of what can happen and whether this can hurt him. As his dad said, little toys and items to children are not just a backpack. That's your personal item. That's something you cherish. And he has memories of it being set on fire and burning in front of him. She's been convicted of negligently by act or omission, placing a child at risk of serious injury. It's a misdemeanor unless the child's under 9, which we have a 6-year-old here. And that makes it a B felony, age 12 years. That under 4035-501 is a 100% sentence. People are impacted by this. I pointed out during questioning that in Exhibit 1, she said, I'm just glad no one was hurt. Well, I submit to the court that people were hurt. It may not be a bump. It may not be a scar in a physical, but it's a mental one. We have Ms. Sanders, who's permanently hurt by this. She's the victim of the reckless endangerment. We have Chris, who's permanently hurt by this. He's the victim of the child endangerment. She's under the influence, DUI. And then on top of all of that, a completely separate action in her purse is a gun that she should never have. She's a violent offender. That gun alone is worth age 12 years at 85%. The state believes the right action in this case is to have Ms. Miles continue any treatment she has while incarcerated and ultimately to be sentenced to 12 years to serve in the Tennessee Department of Corrections in accordance with 4035-501 with the sentences, Your Honor. Thank you.
Mr. Flanagan.
Thank you, Judge. This could have been a completely different sentence in here. Thank goodness it's not. We can talk about all of the factors. The court can look at mitigating and enhancing factors. But I do so much appellate work on these sentencing issues that it usually comes down to 4035-103, which requires that the sentence imposed must be the least severe measure necessary to achieve the specific purposes of the sentencing law. So that's what it comes down to. What's the least restrictive? It's mandatory. The court has to find the least restrictive. She's shown remorse. That was the proof. We know what her issues are: anger management, substance abuse. The testimony is that those are being addressed where she is in the jail to the extent that she is a low risk. I don't think, and I respectfully submit, that a prison sentence under the facts of this case is not the least restrictive. This is, in the normal sense, not an intentional crime. Like I usually have murder cases or child sex cases. The result was not intended like we usually have in some cases. So, you could argue, well, it's intentional because she drank and then she drove. In that sense, I agree, but it's not result intentional. She didn't intend for the result. So it's a little bit different. And she has an extensive record that would justify not giving her full probation. But I think the least restrictive measure would be an alternative sentence of split confinement. She's been in custody for 10 months. The court could sentence her to 8 years with another year to serve in split confinement. The issues that she has will be addressed in the jail because they are now. And they're obviously working because she's now at a low risk. So I don't think a prison sentence under all the facts and circumstances of this case is supported by the evidence.
I may have a brief rebuttal. Your Honor, going to that exact TCA, sentences involving confinement should be based on the following considerations. A, necessary to protect society by restraining a defendant who has a long history of criminal conduct. That's absolutely met here. Absolutely. Confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrent to others likely to commit similar offenses. This is someone who's a convicted felon carrying a gun, and it's also someone who has committed child endangerment by driving impaired and putting as well reckless endangerment of a bus driver. And then finally, measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. I believe I asked Ms. James, and she said that there were 6 violations of probation. So we have a frequency of less restrictive means being applied, and they're not successful. I believe that all 3 of these factors under 4035-103, 1, weigh in favor of the state, and they encourage incarceration to not depreciate the value of this, to ultimately have Ms. Miles incarcerated to protect others. And we've seen that violations of probation, she has 6. It doesn't work. Thank you.
Anytime that I'm required to impose a sentence at a sentencing hearing, I'm required to follow the guidelines that our state legislature has set forth. I cannot just randomly select a number. I'm required to make findings according to the sentencing laws of the state of Tennessee. Mr. Stevens and Mr. Flanagan have both made references to portions of that statute that I am required to follow. And in keeping with what I do in almost every sentencing hearing, the court will refer to those sentencing guidelines in making this decision. 4035-102 sets forth the purposes of this chapter of the sentencing law. The foremost purposes of this chapter is to promote justice as manifested by 4035-103, and in so doing, the following principles are adopted. 1, every defendant shall be punished by the imposition of a sentence justly deserved in relation to the seriousness of the offense. This chapter is to assure fair and consistent treatment of all defendants by eliminating unjustified disparity in sentencing and providing a fair sense of predictability of the criminal law and its sanctions. 3, punishment shall be imposed to prevent crime and promote respect for the law by A, providing an effective general deterrent to those likely to violate the criminal laws of the state. B, restraining defendants with a lengthy history of criminal conduct. C, encouraging effective rehabilitation of those defendants where reasonably feasible by promoting the use of alternative sentencing and correctional programs that elicit voluntary cooperation of defendants. And D, encouraging restitution to victims where appropriate. Sentences, number 4, sentences should exclude all considerations respecting race, gender, creed, religion, national origin, and social status of the individual. It goes on to talk about other factors, but those are the principles that generally have to be applied. Then 4035-103, as both have cited, to implement the purposes of this chapter, the following principles apply. Sentences involving confinement should be based on the following considerations. Confinement is necessary to protect society by restraining a defendant who has a long history of criminal conduct. Confinement is necessary to avoid depreciating the seriousness of the offense, or confinement is particularly suited to provide an effective deterrent to others likely to commit similar offenses. C, measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. 2, the sentence imposed should be no greater than that deserved for the offense committed. 3, inequalities in sentences that are unrelated to the purpose of this chapter should be avoided. And as Mr. Flanagan pointed out, 4th, the sentence imposed should be the least severe measure necessary to achieve the purposes for which the sentence is imposed. 5, the potential or lack of potential for rehabilitation or treatment of the defendant should be considered in determining the sentence alternative or length of sentence to be imposed. The length of term of probation may reflect the length of a treatment or rehabilitation program in which the participation is conditioned of a sentence. And it goes on to say trial judges are encouraged to use alternatives to incarceration, which include requirements of reparation, victim compensation, community service, or all of these. In this particular situation, we have an agreement. There was a 10-count indictment that had been brought against Ms. Miles, citing a number of different offenses. On the 26th day of May of this year, she entered a plea to 4 of those counts, as I previously stated at the beginning. Count 2, Count 4, Count 6, and Count 8. Counts 1, 3, 5, 7, 9, and 10 were dismissed as a part of this agreement. So, in one respect, the plea agreement has already afforded Ms. Miles some consideration and some leniency in dismissing some of those charges that might otherwise have been found guilty of. The court would also point out that in 4035-115 provides the following regarding multiple convictions. If a defendant convicted of more than one criminal offense, the court shall order sentences to run consecutively or concurrently as provided by the criteria in this section. Subsection B, the court may order sentences to run consecutively if the court finds by a preponderance of the evidence that 1, the defendant is a professional criminal who has knowingly devoted the defendant's life to criminal acts or as a major source of livelihood. 2, the defendant is an offender whose record of criminal activity is extensive. Clearly, this 40-some-odd conviction would indicate to me that this would be a criminal who is a defendant who has a record of criminal activity that is extensive. Now, why do I bring that out? Because the plea agreement that was entered in this case is, again, a part of the consideration given to Ms. Miles by both the state, her lawyer's effective representation of her, and by consideration of the state and the victims in this case, agreed that her sentences would not run consecutively. I would not even be given that option, that they would be run concurrently. I am bound by that agreement, and therefore the sentence running consecutively, which could have been done in this case, will not be a consideration that this court can impose. So in one respect, it could be said that Ms. Miles has been given 2 opportunities, 2 advantages in this case that she might not otherwise have received if the matter had just gone to trial and she had been convicted or she had pled to all of the counts, because the court could have imposed consecutive sentences in addition to all of the other charges. So determining the sentence that's to be imposed, we'll start with count 2. Driving under the influence of first offense is a Class A misdemeanor, and this court finds that the maximum sentence should be imposed. I think she's probably already served it anyway, so she is sentenced to 11 months and 29 days in the county jail, ordered to pay a $350 fine and costs her sentence. Her license to drive is suspended for 1 year, and I think I said a $350 fine. The other sentences, Class E felony carries a range of 1 to 2 years on a range, and I do find that part of this agreement was also that she would be classified as a range 1 offender, and so that is the range at which she will be sentenced. A Class E felony carries a range of 1 to 2 years. A Class B felony, as has been cited again and again, carries a sentence of 8 to 12 years in prison. So to determine what sentence she should receive, the range of that sentence, the court must look to the enhancement factors and the mitigating factors, if any, apply. 4035-114 sets forth the statutory enhancement factors that the court must consider. The court has previously, after reading the pre-sentence report and the factual basis, looked at these factors and then listened carefully to the evidence in this case. And this court makes the following findings as to the enhancement factors. First enhancement factor is that the defendant has a previous history of criminal convictions or criminal behavior in addition to those necessary to establish the appropriate range. Court finds that to be a factor that does apply as an enhancement. Number 2 was the defendant was a leader in a criminal offense involving 2 or more criminal actors does not apply. 3, the offense involved more than one victim, and clearly the court does find that there was more than one victim involved, both the bus driver as well as the Ms. Sanders as well as Mr. Owens would be considered by this court to be victims. So number 3 would apply as well. Number 4, the victim of the offense was particularly vulnerable because of age or physical or mental disability. Clearly, that factor also applies because Chris Owens was 6 years old at the time, and I think there's no doubt that he was vulnerable, and all you had to do is watch the video to see his behavior after this accident to know how affected he was. And listening to his parents' testimony, it clearly shows that there was a great deal of effect on him. Number 8 is a factor that sets forth the defendant before trial or sentencing failed to comply with the conditions of a sentence involving release into the community. And that is a factor that this court finds, in my opinion, at least should apply because, as was pointed out, she has been convicted of some 38 or 40 convictions. And of those, she was placed on probation and had 6 different violations of probation. So I do think that was a situation where she failed to comply with the conditions of the sentence, obviously. Number 9, the defendant possessed or employed a firearm or explosive device or other deadly weapon during the commission of the offense. I do not find that to apply, even though I understand Mr. Stevens' argument that the possession of the handgun in her purse was illegal, and it clearly was being held by her in that purse, but it was not, in this court's opinion, actually employed during the commission of the offense. Had she used the weapon in some fashion, that would have been employing it. So I found that not to apply. So I have found that 4 of the enhancement provisions apply to this case. Mitigating factors, the court will go through those. The defendant's criminal conduct neither caused nor threatened serious bodily injury. Clearly, her conduct in this case threatened serious bodily injury to both of the victims in this case. Number 2, the defendant acted under strong provocation, does not apply. Substantial grounds exist tending to excuse or justify her criminal conduct, though they fail to establish a defense. I have no evidence before me that would apply that in mitigation. The defendant played a minor role, does not apply. I do not find that there was any other mitigating factor other than you can make argument that the defendant was suffering from a mental or physical condition that reduced her culpability because of what's been said of her alcohol or drug addiction or whatever, but that's really not a defense. And I do not find that any of the mitigating factors apply in this case. So, in this court's opinion, as Mr. Flanagan pointed out, we could be here on a very different situation than what we are. What I think about is Ms. Sanders testifying about the fact that she had just let off a busload of children at the First Baptist Church right up the hill from that. Had she not let off that busload of children at the top of that hill before this wreck occurred, there was no way that all those children would have gotten out of that bus when it was on fire. And we would have had multiple deaths of children resulting from Ms. Sanders' decision to drive that morning after she had ingested substantial amounts of alcohol and drugs. As a result of that, this court is of the opinion that a sentence of 12 years on count 6, which is child endangerment, is the appropriate sentence. On count 8, I find that the Class B felony in that case, that a sentence of 10 years for possession of the firearm would be appropriate. On count 4, I find a reckless endangerment, a sentence of 2 years would be appropriate. All of those sentences will run concurrently by agreement of the parties. So if she is receiving a 12-year sentence on count 6, a 10-year sentence on count 8, a 2-year sentence on count 4, and 1129 on count 2. I have considered whether or not this would be a case that would be appropriate to allow Ms. Miles to have some sort of split confinement. And had she had 1 or 2 prior convictions, I might consider that. But when you have 40 plus convictions, 6 violations of probation, an escape charge, failure to appear charges, aggravated assault charges, domestic violence charges. I think there were like 4 or 5 of those in your prior record. It is this court's opinion that you pose a threat of danger to the community as a whole, and as a result of that, you must be confined to the maximum I can give you, and I am sentencing you to 12 years in the Tennessee Department of Corrections. That is the judgment of the court for this case. Anything further before we adjourn?
Just for the record, it's 12 years at 30% per the agreement.
That is correct.
It's 100%. We said that on the record.
No, it is.
It's 40-30 for the child endangerment. It's 40-35-501. It is 100%. The gun is the firearm is 85% under 40-35-501Y.
The 100% is the one, the child endangerment. That's the
Yes.
one that she's received the 12-year sentence.
We had that on the plea petition. We said that when we pled her in May, and it's 100%. It's 30% on count 4. It's 100% on 6, and it's 100 down to 85% for the TCA on 8.
All right. That's the judgment of the court. So this court now stands adjourned.
You're on providing a late tender to discover just for the video.
Stevens, you had brought the court file, so I'm going to hand that back to you to turn to the clerk, please. If you're not going to be, I'm sorry, I've got to be there tomorrow, so I can return it.
Thank you.
All right, we stand adjourned.
All right.
Hold on.